and they could just get a piece of paper that certifies them to do something?
Yeah, you can take an OSHA class online and be certified to be on a construction job just with an OSHA, on any construction job site, just with an OSHA 10 card. That's been in New York City law now. I'm not sure if it's New York State law, but and then every 5 years in New York City you have to renew that OSHA 10 course, and that's a minimum requirement that has been, I don't know, taken advantage of in some sense when you see that the DA is breaking down on people selling the OSHA cards and stuff like that.
Yeah, I would be very concerned, and if someone gets that kind of card and they've never stepped foot on a construction site before, that because of their lack of knowledge on how to, I would guess, be in that type of dangerous environment to begin off with, could easily hurt themselves or somebody else.
Absolutely.
Okay. The next question I want to ask is, we were talking about some of the inspectors. You said there's 66 in the state.
Yeah, as of November 2015, there are 66 inspectors in the state responsible for inspecting private sector work sites for safety and health violations.
And
so those are OSHA inspectors.
Okay, so there's 66 OSHA inspectors, and who's paying the OSHA inspector? The federal government, state
Federal
government?
government.
The federal government. So do we in the state of New York that you know of have any law that says how many inspectors we need to have per construction sites or workplaces that are happening in certain areas?
There are...
Or is that all set by the feds?
Well, when it comes to general private sector workplace safety and health inspectors, those are federal employees. Public employees in the state have PESH, which is funded jointly through the state and OSHA, but they're ultimately state employees. As far as other types of safety inspectors, there are people who inspect for safety on public works projects in the state. There are city employees who inspect for safety violations on certain building projects in the city. However, they're not people with the general authority to go out and inspect every construction site in the state. I'm not exactly sure what the answer is to whether or not the state can do that, because it is a matter of federal law. But as far as I know, there's no state law that gives a workplace safety and health inspector unconstricted jurisdiction to go in and inspect any work site in the state.
And I guess my last question will just be, do you know of right now, I'm just not sure, that when there's a bidding process by any type of city or state agency for any type of work being done, is there any way that they can exclude companies that have had a bad safety rating, or do they have to take the bid and apply it just according to cost?
My understanding is that there are restrictions when you look at the competence of the bidder, whether or not they're competent to complete the job. But I'm not an expert on that, and I don't want to make any misstatements about exactly what they are.
And that's more to public works, not on private works. You can be debarred for 5 years, and I think there's companies out there that have been debarred that open up another company with their wives' names, their sisters' names, their son's name, their daughters, whatever, a family member's name, and continue status quo.
Just my last question, Guy. I didn't mean to take up so much time because I just have a lot of questions. But on a typical construction work site, if we have people that have completed or are in apprenticeship programs working on that site, can there also be other workers on that site that have not completed apprenticeship program or not in an apprenticeship program and are there with the lack of the training as others? Does that happen?
Unfortunately, it does happen. When you have a workforce out there and you have developers out there that are trying to rip the middle class people apart, that does happen where they try to divide and conquer. So there could be a work site where you can have largely union and maybe one or two non-union folks in there, if that's what you're referring to, yes. And that's just a fight that we have taken on.
I've heard that sometimes there are work sites that issued stop work orders, and then the companies, as soon as the inspector leaves, continue to do work on that site anyway. Is it nothing more than a fine if you do that?
I'm not 100% sure, but then that goes back to not enough people inspecting jobs, not enough workers out in the industry. When Joe speaks about OSHA, I think OSHA has one representative for New York City that covers, and that's not including the Bronx, and the next one is the Bronx up to Upper Westchester. So it just goes to enforcement.
Okay, thank you very much.
Assemblyman Kavanaugh.
Thank you. I know we're going to hear from a lot of people representing particular trades in particular settings today, but just since both of you have a kind of sort of broad perspective over the industry, are there particular trades or particular work settings that we should think of as posing kind of a greater risk that workers will be improperly trained given practices in the industry?
All non-union. Honestly, there is, you go to the Moncayo case, the gentleman was buried alive, essentially. You go to the most recent case, a gentleman walking next to a shaft, something came down, hit him in his head. All construction work at any level is dangerous. From something falling to just you tripping into a shaft or something a hole not being protected the right way, doesn't matter what trade you're in, you're at risk to being injured or not coming home that day.
And are there, I guess we have a perception that often smaller sites or just kind of renovations or on smaller buildings are more likely to be done by contractors that are not working with unions. Is that a correct perception?
I would think so, and then the safety requirements also aren't there for those smaller buildings as well, and that there's actually city legislation that that's being worked on right now to have like a site safety person on each and every one of these jobs, completely just because of that.
For smaller jobs, yeah. I was with the mayor when we announced that on the Lower East Side recently. Okay, do you have anything to add? Or?
No, thank you.
Okay, I think since we have a lot of witnesses and a lot of members, I think I'll keep my question short, but thank you.
Okay, Assemblyman Moyer.
One last question, and that's to you, Joe. You had brought up the scaffold law, right? And, that's the only labor law that actually is out there to protect workers. There's been recent talks about repeal. Can you give us, in your expert opinion, and tell us what the effect would be if that law was repealed and the effect that it would have on workers?
I think that it would put workers in danger, all workers. But I think that for all of the reasons that we kind of skirted around this, but the bottom line is that employers, unscrupulous ones, will take advantage of people. One layer of protection is a union. On union work sites, workers have much greater protections. But when you're looking at non-union work sites, particularly the folks who aren't even obeying the laws that are on the books now, they employ people who they know that they can exploit. Day laborers, undocumented workers, people who are otherwise marginalized and vulnerable. This law is one of the few that protects everybody doing this type of work, or virtually everybody doing this type of work, whatever your status is, whether you're a union member, non-union member, whether you're documented or undocumented. So I think that it will put all people doing construction work in danger. There are some who will likely feel the impact more than others.
Great. Thank you.
Thank you, gentlemen.
Thank you.
Thank you.
Thank you.
Next up, we have Evan Goldberg, President of the New York State Trial Lawyers Association, Mike Grubber and Matt Funk from the Workers' Injury Law and Advocacy Group. Good afternoon.
Good afternoon. Good afternoon, all. Chairwoman Titus, Chairman Moya, Commission Chair Bronson, members of the Assembly, Dendecker, Mayor, and Kavanaugh. Thank you for the opportunity to testify today. My name is Evan Goldberg. I'm the president of the New York State Trial Lawyers Association. We appreciate this opportunity to present testimony on the important issue of worker safety. The New York State Trial Lawyers Association is an organization of the plaintiffs' bar. Our members represent injured people throughout New York whose injuries could have been avoided if reasonable care had been taken to prevent such harm. The heart of New York's common law is the principle that people should show reasonable care towards each other to prevent harm and injury. This is a community-based standard implemented through our civil justice system by juries made up of members of the community who assess the facts of a case and determine whether or not reasonable care was shown. And it is a particularly important standard because we all know that when someone is severely injured, it affects not only that person, but the people who care about that person. Severe injuries can have devastating effects on families and communities. One of the most disturbing sources of human injury is the workplace. New York State saw 241 reported workplace fatalities and 110,620 non-fatal reported injuries in 2014 alone, according to the Bureau of Labor Statistics. We don't know how many injuries were never even reported. Workers are in a vulnerable position because they do not control the workplace. They must rely upon the employer to keep it safe. Also, if asked to undertake a task, it can be very difficult for an employee to decline for fear of losing his or her job or being sidelined from promotion. Essentially, employees are at the will of their employers, often untrained, unsupervised, unknowledgeable, and asked to perform very dangerous tasks that most wouldn't even think of performing on their own. As plaintiffs' attorneys, we see a very direct relationship between workplace injuries and public health and safety. An unsafe construction site, for example, not only can pose a risk to workers, but also can result in falling objects that injure pedestrians. According to the Bureau of Labor Statistics, construction accounts for 4 of the 10 most hazardous jobs in our country. But inspections are few, and penalties are not high enough to be effective, and they're often targeted at the wrong actors. A recent review of OSHA construction site inspections in the Buffalo area, for example, found that the agency conducted only 1 inspection per weekday on average over a 10-county area. But nonetheless, for those inspections, they found 83% had violations, with 86% of those violations classified as either serious, repeat, or willful. We clearly need more compliance in construction. Between 2012 and 2014, construction accounted for 22% of all occupational fatalities in New York, even though it comprises only 4% of all employment in the state. The U.S. Bureau of Labor Statistics reports that between 2011 and 14, 169 occupational fatalities occurred in construction in New York, and it reports that in 2013, there were 2 non-fatal injuries per 100 full-time workers in construction, 2 out of 100. While the non-fatal construction injury rate has been lower in New York than in the nation for many years, thousands of construction workers in New York still report an injury each year. Construction is only part of the story when you talk about workplace safety. In healthcare, for instance, understaffing of bedside care or failure to provide proper equipment for lifting and moving of patients can be harmful for the nurse or nurse's aide as well as the patient. Indeed, it surprises many who learn that the rate of musculoskeletal injuries for nursing aides, orderlies, and nursing attendants is 7 times higher than the average of all occupations. OSHA notes that healthcare workers also face risks from bloodborne pathogens and biological hazards, among others. OSHA observes that more workers are injured in the healthcare and social assistance industry sector than any other. NISBA believes that improving worker safety in healthcare, including better infection control, implementation of the 2014 Safe Patient Handling Act requiring safe lifting equipment and protocols, and the implementation of safer staffing levels in both hospitals and nursing homes will improve the safety of patients and nursing home residents as well. We strongly urge that greater attention be focused on healthcare work settings. Another area of focus is upon all the workers that are out there on our roads. Driving fatigue and driver distraction are worker hazards that also pose severe risks of injury and risk to the community. In a survey of New York drivers, a higher reported frequency of driving drowsy was associated with working a rotating shift or a greater number of hours per week and more frequently driving on one's job. On the other hand, a study found that in New York City, taxi cab and livery drivers had a 1/3 lower crash rate than any other types of vehicles, and suggested that one of the factors likely relevant to the statistic is the Taxi and Limousine Commission's strict regulations for driver safety. These are important considerations statewide as New York considers safety measures related to taxi, limousine, and rideshare systems. We praise this committee for focusing on the issue of workplace training and safety programs. We also praise the nonprofit and union organizations that work so hard to promote workplace safety, but we know that they cannot reach everyone. It is therefore essential to focus on the employer as an additional target, not only for workplace safety education, but also for standards and oversight. Accountability is critical because of the constant temptation to cut corners on safety in order to meet a deadline or to increase profit margins. New York must maintain the laws that it currently has in place for workplace safety. The legislature should scrutinize very carefully any claims made by those who would seek to repeal safety standards, since assertions of problems being caused by safety measures are often spurious. In particular, there must be transparency regarding the basis of such assertions, because the stakes for workers, their families, and the community are very high when worker safety measures are threatened. Finally, the legislature should protect the rights of employees who are injured on the job to workers' compensation benefits that they need. You'll hear more about this from the workers' compensation bar and the gentleman to my right. If there's concern about the cost of workers' compensation, the solution should be to improve worker safety, not to take away workers' rights. Improving worker safety will benefit workers, their families, and the community, and all of New York. Again, we thank the Assembly Committee on Labor, the Assembly Subcommittee on Workplace Safety, as well as the Assembly Commission on Skills Development and Career Education for this opportunity to testify. New Yorkers are well served by these hearings and by your service. Thank you.
Thank you. Mr. Funkin-Grubber?
Yes. Greetings, Chairwoman Titus, Chairman Bronson, Chairman Moya, Assemblymember Kavanaugh, Mayor, and Den Decker. My name is Matt Funk. I am a workers' compensation attorney. I'm here today to discuss what happens after a worker is injured and how proposed changes to the workers' compensation law, both here in New York and nationally, present a growing threat to the ability of injured workers to recoup benefits and to return to work in a timely fashion. The testimony that's going to be presented today is going to paint a picture of the perils that face workers every day on their job site. However, if a worker is injured in the course of their employment, they face an even bigger obstacle to secure financial and medical benefits. The worker must go through the workers' compensation system. As you know, the workers' compensation system was a bargain struck between labor and business in the 1920s. The deal was that injured workers would give up their right to maintain a lawsuit against the employer in exchange for timely payment of medical expenses and wages. That bargain has slowly eroded. Now, in 2016, an injured worker must fight harder than ever to make sure that they receive prompt medical care and a living wage to help support their family while they recover and attempt to return to work. In 2007, we saw the first major limitation on the amount of benefits that an injured worker can receive. Permanent partial disability benefits were limited to a maximum of 10 years. This was a decrease from lifetime benefits. In exchange for this cap, injured workers were given an increase in benefit rates. However, a majority of workers have not benefited from that increased benefit rate because their average weekly wage was not high enough to qualify for the new maximum rates. These hard-working individuals who had suffered lifelong injuries at work instead saw their benefits capped without anything in return. Recent changes at the Workers' Compensation Board have added confusion to the benefit process. A few months ago, the Workers' Compensation Board decided to stop issuing notices of decision that list the body parts hurt by an injured worker if there was less than a week of lost time. The notices of decision are an important aspect of the workers' compensation law, since it details the exact sites of injury that the injured worker had, and it allows the injured worker to present that notices of decision to their doctor to get treatment. Without these decisions, an injured worker is left lost as to what sites of injury are accepted, and also with a 2-year statute of limitations, without having documentary proof from the Workers' Compensation Board of what sites are accepted, an injured worker may be without benefits by not timely filing a claim. I can tell you that I've looked at multiple cases every day, and sometimes I'm confused with some of the documents that are in the Workers' Compensation Board file. Now imagine an injured worker with limited education, limited command of the English language, and no attorney. How will that injured worker know what the case is accepted for, what body parts to get treatment for? The system that started out as a bargain to ensure prompt treatment to workers is becoming more and more of a hindrance to those workers. New York should not put up roadblocks to benefit injured workers. We must protect the benefits of the hardworking men and women who keep this state running. We must also be wary of proposed reforms to the system that would, in actuality, strip workers of their rights and benefits. Streamlining the workers' compensation system is a laudable goal, but too often we see that reform is just another word for reneging on the bargain that created the system. Thank you.
Thank you. Let's start with any questions.
Wait, here's one more.
Oh, I'm sorry.
Thank you. Good afternoon. Chairwoman Titus, Chairman Moya, Chairman Bronson, Assemblyman Decker, Assemblywoman Mayer, Assemblyman Kavanaugh. My name is Michael Gruber, and I am the President-elect of the Workers' Injury Law and Advocacy Group. The Workers' Injury Law and Advocacy Group is a national nonprofit organization dedicated to representing the interests of millions of workers and their families who each year suffer the consequences of workplace injuries and illnesses. Our group acts principally to assist attorneys and nonprofit organizations across the country in advocating for rights of injured workers. In 1972, Congress created the National Commission on Workers' Compensation, which outlined 19 essential recommendations for workers' compensation systems. For a period of time, the Department of Labor monitored state compliance with these recommendations, but unfortunately, in 2004, that monitoring stopped. Over time, and especially since the Department of Labor monitoring stopped, there has been a gradual erosion of workplace benefits for injured workers on the job. Nationally, we have seen limitation on employer choice of physician, implementation of arbitrary rating systems such as the AMA guidelines, the shifting of the burden of proof from the employer to the injured worker, apportionment of disability and causation. Each of these changes is detrimental to the injured worker. Benefits have eroded nationally to the point where courts in some states, such as Florida, are considering whether the reduction in benefit levels have fallen to an unconstitutional level. In New York, we have seen benefits eroded as well. New York has adopted artificial limitations on durations of benefits, going from lifetime benefits to capped awards that significantly reduce.
Your mic, hold on.
Sorry, it tells me not to bend this mic, so I'm trying to follow the rules.
That's
Good. Excellent, thank you. Sorry about that. We've seen the limitation of benefits that Mr. Funk talked about, going from lifetime benefits to capped awards, significantly reducing the percentage of wage replacement benefits available to low-income workers. New York has also adopted artificial medical treatment guidelines. These have led to the Workers' Compensation Board utilizing what is known as cookbook medicine, where treatment is governed not by the best judgment of the employees or injured workers treating physician, but rather by the strict formula of the medical treatment guidelines. It has become virtually impossible for an injured worker in New York to obtain authorization for any treatment that falls outside of those guidelines. This has resulted in there being significantly limited access to medical care by making it increasingly difficult for medical providers to function within the New York State workers' compensation system. At some point, I believe we have lost sight of the principal purpose of workers' compensation systems. Workers' compensation is remedial legislation designed to protect the rights of injured workers. The system is charged with replacing lost wages, paying medical expenses, and allowing an injured worker to recover and return to work as quickly as possible. However, proposed changes are now focused on reducing costs for businesses as opposed to finding an appropriate balance between the rights of employers and employees. Too often, we have seen proposed changes around the country that would strip away even more rights from injured workers in the name of cost savings and so-called reform. The results of workers' compensation reforms show that these changes negatively impact workers almost in every state where they're enacted. Nationally, a June 2015 OSHA study reported that workers' compensation insurance carriers are now only liable for approximately 21% of the cost of work-related injuries. Governmental entities, and therefore taxpayers, bear 16% of such costs, while 13% of the costs are paid by private health insurance and private insurance carriers. Who bears the majority of the cost for a work-related injury across the country? Unfortunately, it's the injured worker. According to OSHA, a staggering 50% of the cost of a work-related injury is now paid out of pocket by an injured worker. Similarly, on a local level, a NICOSH report determined that New York's 2007 changes resulted in workers' compensation now replacing only approximately 10% of wages lost by a permanently partially disabled worker. Costs of the workers' compensation system, both nationally as well as in New York, have been shifted from the workers' compensation insurance company, the party who should rightfully bear the burden of such costs, to other entities such as governmental social welfare programs, private insurance carriers, and worst of all, to the injured workers themselves. Injured workers need the protections of workers' compensation systems. The legislature must reject the national trend of placing increasing burdens of workplace injuries on injured workers. Again, we thank the Assembly Committee on Labor and the Assembly Subcommittee on Workplace Safety, as well as the Assembly Commission on Skills Development and Career Education for this opportunity to testify. Thank you.
And thank you, gentlemen, for your testimony. With your expertise in this particular area, I just wanted to ask you, can you, I guess, describe any recent trends showing employer violations, and are there any data showing any new trends in the ways that employers are violating the law? Do you have any?
Well, the statistics that I mentioned in my report, I could repeat them. What maybe you're asking is whether there's a feeling out there that things are getting worse, that people are being put at risk more than ever, whether violations are rampant. I believe that violations...
A particular area of violations that you're seeing more prevalent than
I wouldn't have a way of distinguishing one violation over the other, except to note that the OSHA violations were reported as serious or willful in 86% of the violations that they issued. So by definition, they pose hazards to the health and safety of their workers.
One thing that I've noticed, I don't have an exact statistic on it, but there, I believe Joe Canavas had mentioned this about employers that do not carry workers' compensation insurance. When you have an employer not carrying workers' compensation insurance, it creates a really undue delay for the injured worker to get benefits. The length of time that will take at a hearing to secure the compensation for that injured worker is almost double what it would be if that employer had workers' compensation insurance and followed the rules of the workers' compensation law. So one thing that needs to be done is to make sure there are inspectors going out and making sure that these employers carry workers' compensation insurance in case there is an injury on the job.
All right. Thank you. Assemblyman Moya?
In your experience, how many of the injured workers that are seeking your help are of color?
When you say my help, you mean my firm in
Your-
particular or my industry?
Your counsel, your industry.
Well, certainly the Latino community, people of color, make up the overwhelming majority of people injured on the work site. They are subjected to risks without proper training, without proper supervision, without proper safety measures erected in place on a grand scale. So yes, indeed, it disproportionately affects people of color and the Latino community when there's a failure to provide proper protection on the work site as mandated under the labor law.
Is there a, do you see a large trend of undocumented workers that come to seek help from your industry?
Certainly. Many undocumented workers, as you know, Chairman Moya, They're picked up as day laborers on the site. I told a story on a panel with you just a couple of months ago how a worker that I represented comes to my office with a few missing fingers, and I asked him, where were you working? He had no idea. Who were you working for? He had no idea. Give me some information. He gave me nothing. I had to hire a private investigator to find out where he was working so that I could bring a lawsuit. They picked him up on the street. They didn't even want to take him to the hospital. They wanted to disavow any relationship with him whatsoever. So it's not only that they're exposed to more hazards by virtue of being untrained and placed in the type of hazardous jobs that union workers would not be subjected to, but once an accident happens, they're victimized yet again by not being able to avail themselves of the safeguards under the law by bringing an action because people want to forget they ever existed.
And thankfully, New York is still a state whose law is very clear that undocumented workers are covered by the workers' compensation system. I will tell you that nationally, that is one of the trends that we are seeing across the country, is that state legislatures are trying to carve out exceptions to deny workers' compensation benefits to undocumented workers. In our practice, in terms of your initial question with respect to people of color or different ethnicities, workplace injuries really don't know any color. I mean, obviously in the city we deal with every type of injury. Our practice is a statewide practice, so across the state we see workers of every type. Obviously, undocumented workers tend to be, unfortunately, people of color or different ethnicities. And again, you heard it mentioned in the testimony previously given, that the undocumented workers are usually, or in often cases, working for people who don't want to have workers' compensation coverage. I hear stories every day of workers who come to me and say, well, my employer told me to say it happened at home. My employer took me to the hospital and told the hospital that it happened in playing basketball. My employer threatened to report me to the government to try to have me deported if I file a workers' compensation claims. These are the types of threatening gestures that it's very important that our legislature take a strong stance with undocumented workers to maintain their eligibility for workers' compensation benefits.
And I think that is something that resonates very, very highly with all of us here, especially me in a community that has a great population of undocumented immigrants. A lot of them are day laborers. We hear these stories, these tragic stories, all too often. And we hope that in light of these hearings, we can do something to start preventing these stories from continuing to happen. There was also talk about scaffold law in the previous testimony. How many scaffold law cases do you receive in your industry as well?
Oh, there are a substantial amount of scaffold law cases. Injuries from elevation-related hazards are among the most prevalent in the construction industry and have the greatest effect on workers. They have the potential to cause the greatest harm when people fall from great heights or when objects fall upon them. The labor law, the scaffold safety law, which is what I believe you're referring to, has protected workers who have been working at heights for over 100 years in New York. And New York, by comparison, has enjoyed one of the best safety records in construction in the country. And even with that, it's still staggering the amount of accidents that exist. So those who would seek to repeal the law are misguided, because there is absolutely no reason to take away the safeguards that we have in place that have facilitated the construction of this city, of this state. All the buildings that you see around you were erected with the protections of the scaffold law in place. And the only reasons being proffered to take away the protections to workers are because insurance costs too high, but they don't prove it. They don't prove it at all. And in fact, the insurance industry, the carriers, are reporting record profits. So there's no justification there. Another thing we heard in recent years was that construction is stagnated. Well, construction is booming. Look around. everywhere throughout the state, construction is seeing a surge, and it's cyclical. It goes through ups and downs over the last 100+ years, all with the labor law in place, all with New York valuing the safety and well-being of the New York worker and his or her family. That's something that should never, ever change.
Just two more quick questions, and just going into that. Do you see that there is more issue with the lack of training or with the lack of safety equipment that is provided on the job sites?
Honestly, they're both a problem. They're both a very, very substantial problem. With training, you have to be careful not to shift the responsibility for providing a safe work site onto a worker who is unsophisticated or uneducated. So it's easy to say when an accident occurs that, well, the worker wasn't being careful or he wasn't trained properly. But in fact, there's an overriding responsibility of the owner, the general contractor, the construction manager to make sure that the work site itself is safe. Listen, the construction industry has been in existence for a very, very long time. It's a learned industry, full of engineers. People go to school for this. People have degrees in all the sorts of issues that arise on a construction site. The concept that accidents just happen has no place on a well-run, legally compliant work site. It just has no place, because we hold construction managers and owners and general contractors and contractors on jobs to the standard of prioritizing safety over profit. But unfortunately, many times we see that just the reverse takes place.
And lastly, is it safe to say that most of the cases that you receive are non-union workers?
I would say there are more accidents on non-union type jobs, certainly. That is my that's my opinion. I don't have the statistics at hand, but I believe there have been some studies that show that to be the case.